I think the majority leader, Senator, articulated it best by referencing the witness who was present at the Assembly Committee, wasn't unfortunately able to make it today. The crime that impacted her dates back 14 years, and she would be left out without potential redress if the amendments were adopted. For victims of these sorts of egregious crimes, systematic crimes in particular, it frequently takes many years, as the majority leader mentioned, to essentially be in a position to get your lives back in order and be in the frame of mind to seek legal redress. I can speak very specifically about my community, and that the 50 years that followed the genocide, it was so devastating when 2 out of every 3 members of our community were brutally killed, that the remainder, when they were scattered, used that period just to try to, for their daily existence, trying to survive, and then gradually establish communities, build churches and schools and other institutions in their new locales, be it the Middle East, Europe, America. And many of these victims ended up in the United States, and particularly in California, where our state was generous enough to offer refuge. But it took quite a long period of time, and I think that can be said of victims of such horrific crimes whenever they occur. And it's very encouraging to hear that committee members seem to be supportive of a 10-year statute of limitations. I think that's an extraordinary step in the right direction. But it would be extraordinarily helpful to also afford communities that haven't had the opportunity this narrow 2-year window in which to seek a redress. And again, claims that aren't meritorious aren't going to go anywhere and shouldn't impact our legal system. So.
Just to speak a little bit more on the crimes against humanity point.
Very briefly, we've got 15 other bills, so we've got to wrap it up. Did you have any questions, Senator Leno? Okay, if you could very briefly, please.
Yeah, I was just going to say, the way that crimes against humanity is defined in the bill, it has to be widespread or systemic, planned acts of rape, murder, the worst of the worst crimes. So that's really what this bill is going after at the end of the day. It's not somebody punching your nose in Mississippi. It's much deeper than that. And that's also why we don't anticipate a flood of claims, because we really don't think there's that many claims that are available out there, especially because of personal jurisdiction standards. Only California citizens or people with extreme connections to California are going to be able to be sued, because international shoot is the federal law.
Thank you. Senator Wieckowski, any more questions?
I'll move the bill.
Senator Leno.
Thank you, Madam Chair. As the token Democrat non-lawyer on the committee, my questions will be somewhat shallower, if not as probing as the good job that my colleagues have done. But getting back to something that Senator Jackson had mentioned earlier, and I hope you know, and all of those who have come here today to support the bill know, irrespective of the questions being asked, there's not a heart in the room that is not sensitive. And let me add my membership to the Jewish caucus here as well. We all have shared this history. We all know what this is about. But the question is, I think from some of your responses, I have a sense of what the answer is, that the 115-year is somewhat arbitrary, but not all that arbitrary. But I also, and I think we need as a committee to look at what likelihood there will be should this go forward with the 115 years in it. Should we expect another bill? Because look who's left out if we draw the line at 115 years. Should those who were enslaved in this country not have some redress? Were they left out intentionally? I wouldn't suggest that, but shouldn't they be included? And if we go back that far, as the chair mentioned, why would we leave out Native Americans from all of the suffering that this country had caused them. So it does open a gate to others with just as sound a case, and I don't know how any of us then stand on any ground to say, well, that's going back a little too far. So as difficult as it is because of the righteousness of the reasons for your being here with Assemblyman Holden's bill entirely, there are reasons to have concerns. So it's difficult. It's very difficult for many reasons, mostly emotional, not the aspects of law I was never trained in.
I think that's...
I'm just going to finish up real
Yeah,
quickly.
please.
That there is some wisdom, more than some, there is significant wisdom to what the chair is suggesting here today. And so I hope the author, as well as the sponsors and those who are in support, recognize why her suggestions make this actually a stronger bill, possibly more likely to get signed into law, as well as more likely to sustain any constitutional scrutiny.
If I
Please,
could, and
please.
I really do appreciate your comments. I appreciate all of your comments. I think that they have been thoughtful. They've been reflective of the workability of some of the aspects of the bill, and I understand how that would float to the top, and you would zero in on the areas that you have. I would just give, and I would join you as being a non-lawyer in the room, but I would give my best shot at why 115 years and not 315 years. Many of the families and people are still living. Information is still shared within families. That printed material and factual information, my heart always bleeds every year that we remember the Holocaust here in the Capitol, that we remember the genocide, the Armenian genocide, and the numbers dwindle each year in terms of actual members who were exposed to those kind of atrocities and those type of genocides, but it is passed along to a generation, and there is information that can easily or more easily be shared and documented. If you go back too far, obviously it becomes much more difficult. But I think within the last 115 years, there are family members that are still alive who maybe had a relative who had a genocide imposed upon them. That's my best shot at trying to suggest, and I would look to the witnesses, but I agree that there is a narrow universe here, and by having the 2-year period of time to allow for anything that happened 115 years ago to make it through the eye of that needle, it creates an opportunity, a short-lived opportunity, that if there's someone out there who has a claim, we haven't shut the door on them. And having said that, I can't say enough about the chair's thoughtfulness and trying to find that middle ground. And you know me, I will usually be responsive to that. In an issue like this, and I conferred with those who brought the issue to me, it became very difficult to do that, recognizing what they were trying to accomplish and what we were trying to help them accomplish. But I will say that in closing, I appreciate your giving this consideration, hearing the concerns, giving it our best effort to try to be responsive to the judicial process and how it would work through that process, the emotional part of it, the time frame, the retroactivity part that we think is important to address. And we think that this is a good bill, and we ask for your consideration and your aye vote.
Thank you. We'll take that as a close. I will just say that I don't know, practically speaking, how you'd implement that if someone has a claim, they have to be alive, or then hearsay recollections and so forth are imposed. I appreciate very much on behalf of my family that did not survive an atrocity, a Holocaust, and for those of many groups. I think of, you know, throughout history, there have been so many. I do think that that it's not that my suggested amendments, I think, would have made this a bill that I could support, and that I think would have honored and respected our process of jurisprudence. I just think going back 115 years really takes that away, and that's why I asked that you make it prospective rather than retroactive. So I'm going to have to oppose the bill, and but appreciate and hope that you appreciate too that it's not because of any lack of concern or empathy. You know, on behalf of my own family, I hope my Zadie isn't, you know, rolling over in his grave, but I just think for the integrity of the system that this is not the right way to go. Senator Hertzberg, very briefly, and then...
Chairwoman Isakovich.
Yes, yes, indeed. All right, with that...
No, that wasn't with that. That was the response. Two quick things. One, this is not keyed fiscal, but I'm told it's going to appropriates. Is that accurate? Is that true? Two, is there a particular case that you have in mind for this? I mean, it seems to me that this measure is about a case or individual case. Is there any, in terms of the proponents of this stuff, is there something specifically that we should know about? Or are we going to pass a bill that no one's ever going to take advantage of? It seems to me that someone's got an idea, and let's put it on the table. Is there something at all that we know of? And why 115 years? Nobody's 115 years old around that I know of, you know?
I mean, there's no specific case that we have in mind. I will say the 115 years, as we explained, it dates back to the 20th century because there have been these modern genocides in the 20th century that we wanted included, including the Armenian genocide. You know, going back to a round number was a little bit easier, frankly. But as far as specific cases, one specific case I would like to highlight, you know, which I did in my testimony, is the witness that we had here. She was trafficked in 2000. Yeah, but... True. I'm just saying, without the revival provision, she wouldn't be able to bring claim either. But do you want to speak to the 115 years? I think we've got that answered. We've taken about an hour. It's certainly an important issue. Let's call the roll. This would, if it were to pass, it would be due pass to Senate Appropriations. If it doesn't, you could seek perhaps reconsideration. But let's just see where we all fall in this. I think it's certainly deserving of a vote. All right, we have a motion by Senator Wojtkowski, due pass to Senate Appropriations. Please call the roll.
Jackson?
No.
Jackson, no. Morlock? Yes. Morlock, aye. Anderson? Hertzberg? Leno? Monning? Wojtkowski? Aye. Wojtkowski, aye. 2-1.
All right, that bill has 2 votes. We'll leave it on call. Thank you very much to all of you, and appreciate your testimony. All right, let's move along here. We have Assemblymember Gatto in my committee, and I'm supposed to be in his committee. So let's see what we can do here to get these bills heard. The first one is AB 83. Assemblymember Gatto, please go ahead and present.
So the bill before you is Assembly Bill 83, which has to deal with the way in which businesses handle certain kinds of personal information. There has certainly been a lot of impetus in the public right now to come up with, to have their government and have their elected representatives come up with some sorts of standards that the legislature can put into place. Alrighty then, way to clear a room. Some sort of standards that the legislature can put into place to maintain the integrity of personal information that is stored by businesses. We toyed with lots of different possible standards. We toyed with having putting in place a specific type of encryption, and we were told after researching the subject thoroughly that obviously putting that type of mandate into a bill would be pointless, because after, probably by the time the bill passed and was chaptered into law, that type of encryption standard would already be outdated. We toyed with providing the Attorney General with the ability to promulgate regulations every year about what constitutes appropriate encryption and appropriate security measures for different businesses and different types of data. But then when all was said and done, we ended up on a standard that is very familiar to all the attorneys in the room, and I think all the attorneys in the room all walked out. But this, of course, is the reasonably prudent actor standard. It dates back to 1837, of course, in the United Kingdom, and that is the Vaughan versus Menlove decision. And in the United States, it dates back from the seminal Second Circuit decision with Judge Learned Hand, and I believe that was the U.S. versus Carroll Towing decision. So that standard, we think, is the best one. Businesses have been using it, for decades now. They're familiar with it. They know how to do it, and there's lots of case law that construes that standard. We also modernized the definitions of personal data to include things like biometrics. Of course, that is basically things like eyeball scans, and geophysical geolocation data, which is where you go at any certain time, which can be used to track individuals. And we think this balances the different considerations that I just mentioned, and we would respectfully ask for your aye vote.
Thank you, Assemblymember. Did you also introduce with authors' amendments?
Yes, indeed. We have the authors' amendment, yeah.
Okay, very good. I appreciate that. Thank you. 2 witnesses, 2 minutes each. Whoever would like to. Very good.
Thank you for this opportunity to appear before the Senate Judiciary Committee. It's an honor to speak for you. I am Paul Schwartz, Jefferson E. Pizer Professor of Law at Berkeley Law School, co-director of the Berkeley Center for Law and Technology. I'm also a special advisor to Paul Hastings, a global law firm. All the views that I express are solely my own. I'll state my 3 brief points and then elaborate also briefly. My first point is that AB 83 is part of a national trend to require data handling organizations to implement reasonable security obligations. These reasonable security obligations are different than data breach notification standards. Second point, the reasonable security laws are a necessary response to the rise of personal information held outside of our personal computers. Third point, AB 83 is an important part of creating a reasonable business environment for the information age. It is a pro-business statute. Point 1, the national trend. California enacted the first national data breach notification law in 2002. It followed in 2004 with the first statute that requires companies to maintain reasonable data security. Today, we consider ABA 83, which offers modest amendments to the 2004 law. The California requirement of reasonable data security has now been followed by 7 other states, and these 7 other states largely followed the California model. These laws, as I said, serve a different function than data breach notification. They establish a modest baseline of reasonable data security for certain kinds of personal information. Point 2, it seems almost unnecessary to discuss the rise of data security problems in the U.S. To make the top 5 list of data breaches today, a company has to lose 100 million or more records. The key point is that all of our data security is now at risk, regardless of our personal behavior or our personal computing practices. Our data security are at risk because of the scale of data theft. Criminals do not need to hack into your system to steal your personal data. Instead, they can hack into large corporate databases. This means that we all now depend on the security of outside organizations. Moreover, some of these organizations are ones that we do business with, but some are those that we may not know even exist, let alone that they have our personal information. My final point.
Great. If you'd wrap up, please.
Yes. Businesses face constant choices in deciding where and how to invest in their operations. In the absence of security requirements, companies will underestimate insecurity. A company's poor data security creates harms to others, and the law should make data handlers bear a reasonable security cost to help prevent these harms. In conclusion, ABA 83 protects consumers while also serving a pro-business function. It rewards businesses that invest in security, and it safeguards the data ecosystem for all of us. Thank you.
Thank you very much. And as someone who did get notice that my security had been, or my information had been breached by someone I didn't even know, a company that worked with a company I did know, I appreciate those observations very well. Next witness, please.
Rodney Wilson with the California Credit Union League. Senators, the Credit Union League has long history of supporting data security measures, and we appreciate Assemblyman Gatto's efforts to enhance the security standards that are lacking in the law. This will require businesses to protect all information, especially payment card information, debit and credit card information that our folks care very much about. And it's, as you've seen in the recent media coverage, there's been several high-profile breaches in the area. We strongly support AB 83 and respectfully ask for your aye vote.
Thank you very much. Next witness, very briefly, please.
Samantha Corbin on behalf of both Privacy Rights Clearinghouse and Electronic Frontier Foundation in support of this bill. Thank you.
Thank you very much. Other witnesses in support? If you just step up to the mic, name and affiliation, if you would.
Becca Kramer, ACLU of California, in support.
Thank you. Any other witnesses in support? Are there any witnesses in opposition? Okay. All right. Good afternoon. If you'd like to go ahead and proceed.
Thank you, Madam Chair. Robert Callahan with the Internet Association. We are opposed unless amended, but first and foremost, I want to say thank you to the author and his staff for working with our industry and others throughout the year. The bill's made a lot of progress. Their office has had a complete open door policy for us, and we truly appreciate that. Second, I'd like to say our member companies, internet companies in the United States are leaders in security. There's no question. We implement some of the world's most advanced technologies and techniques for security. And so we take no issue with the reasonable requirements that are laid out in this bill. We certainly would never want to go against the wisdom of learned hand, of course, either. But so we're not concerned with that portion of the bill. Our concern rests, frankly, with what's being required to be behind that firewall of protection. The bill's adding a number of new items to the list of personal information. The analysis rightly points out that as everything's becoming more digital and as hackers make increased and more sophisticated efforts to hack into systems of companies all around the planet, these types of things are happening more often. It's certainly something that our members spend a substantial amount of time dealing with. The issue we're seeing here is we're adding more and more items to the list of information that must be behind this firewall, some of which we think may not make as much sense given the prioritization that probably needs to happen for many businesses, including our own. So first on biometrics, we actually think that fits pretty well into sort of the types of data that this law has typically protected. Biometric information used to authenticate an individual could provide access to sensitive accounts and systems, which sort of is reflective of some of the other things in the legislation, and in the existing statute, like username, password combinations, like social security numbers, bank account information, credit card information. We are uncomfortable at this point with geolocation being included in the bill. First and foremost, because we think the definition is overly broad. The way it's written, it would include any information that could describe a person's location, not just specific information. So that could include a country, state, city, et cetera. We also don't think it's necessarily the right time to be adding this to the to the data security law. While it's not covered in this bill, and don't want to say that it is, we are concerned as an industry that this information will be mirrored in the data breach notice law, and specific pieces of information like being at a pizza joint, requiring a data breach notice to be given out to consumers may dilute that information that they are receiving compared on the same footing as social security numbers, et cetera. So we are opposed unless amended for those reasons. Thank you.
Very good. Thank you. Next witness, please.
Madam Chair, members, Jeremy Merz on behalf of the California Chamber of Commerce. We're in a similar posture with the Internet Association. We too have an opposed unless amended position on this bill. We do recognize the importance of consumer data security and the confidence consumer has in us protecting certain information. We too do not oppose the portion of the bill that was talked about by the first witness dealing with the reasonable security standards. That's not an issue for us. Neither is some of the expansion of the definition of personal information, specifically the harmonization with the data breach portion of the Civil Code, which includes health, insurance information, online account information. But as Mr. Callahan stated, we do oppose expansion of the definition of personal information to information that is not harmful to consumers. We look at the history behind this statute. It's to protect against identity theft, to protect against the type of information like social security numbers, health information, financial account information. And we think some of the stuff that's been added to this definition isn't on par with those pieces of information. For example, Mr. Callahan talked about geolocation in the overbroad definition, also signature. Signatures are ubiquitous. Signatures in and of themselves don't allow people to open an account, don't allow for identity theft. So we just think that there is some things that have been added to this definition that and go too far, and there's always going to be arguments to expand personal information. Certainly there's a lot of information out there. We just remind the committee that every time we expand this, we add to businesses, we force them to expend resources, expose them to litigation.
I get to be chair now.
Okay. So, yeah, we do thank the chair for the efforts so far, and we are in an opposed unless amended position.
Thank you very much. Are there any other witnesses in opposition?
Price with TechNet, opposed unless amended.
Margaret Gladstein on behalf of the California retailers. We too are opposed unless amended, and I echo the comments of Mr. Mers, and also want to thank the author and look forward to continuing to work with him on these issues.
Anyone else? Senator Hertzberg.
Point of personal privilege, Mr. Chairman. I want to know how this is relevant to Tier 1, Tier 2, and Tier 3 of Prop 98.
Wow. You know, I can't answer that question, Mr. Hertzberg, so I fear that I've lost your vote due to that.
No. Why didn't you apply this to government?
Well, we've had...
Does government have a lot of information that should be held to the same standard? Don't we set up a dual process if we don't apply to government, although it's going to cost a lot of money and make it go through appropriations, Mr. Appropriations Chair?
Yeah, that was our precise concern. I mean, we had hearings about, we had hearings in my committee in the Assembly side about how much data government stores and how dangerous it is if there is a governmental breach, because the things that government collects are things that are very personal to people, healthcare data, social security numbers, tax information.
Right.
We got some disturbing answers back from government. The gentleman from the DMV could not even answer how many times that they had been broken into, hacked.
But did he acknowledge that they have been hacked?
Yeah, he
didn't know how many times.
He did not know how many times. I mean, most people in this realm, there was that famous speech that the chairman of Visa gave when Barack Obama visited Silicon Valley. He said, Visa's been hacked. Visa's been hacked. Visa's been, I mean, the number of breaches, it's not a question of when, it's a matter of it's not a question of if, it's a matter of when. We would have bought a profound appropriations problem for an issue that is far broader than this bill. I think that the legislature is wrestling with how to make all of our governmental systems and the administration with how to make our governmental systems more safe. And I did not want to wade into that controversy, which probably would have bought us a huge appropriations cost and probably a veto at this stage. Yeah, so.
It's an unfortunate statement, but I think accurate, you know, because it is right. I mean, people have confidence when they file their tax return. They can make commercial choices as to what to do or not to do. But when the government comes in and says, you got to give this information, you turn it over, and now you're at their mercy. And if they're not held by the standards to which you have appropriately identified, to what end? And then, I completely agree. It's just somehow we're going to have to cross that bridge pretty soon.
I agree. I concur.
Senator Gatto, I just had a few questions. No one wants to have their house burglarized, and no one wants to have their IT system hacked. But it sort of happened. So I'm just curious, how is this enforced? How is your proposal enforced?
Well, it's like all statutes like this, it's enforced based on a case in civil court. If something is, if there's an egregious enough breach, the legislature has set by statute the appropriate standard of care. If someone violates that standard of care, it would subject them to liability. We did not put a specific cause of action in this bill. We did not put we did not specify damages in this bill. We did not specify attorney's fees. We did none of that. We purposefully punted on that issue, but all of these statutes that we create, they're enforced one of two ways. The Attorney General coming in and saying you violated the law, which the Attorney General is always free to do, but in practice those type of prosecutions are rather rare, and then they're enforceable by the public at large. If there's a broad enough, breach, and the public wishes to come forward and say that it was outrageous. It was not a reasonably prudent thing to do to leave a laptop with all of my health information on the train, with no password. Then it would be up in that instance for a jury or a court to determine if that was indeed unreasonable. So same thing as tort law. I mean, same thing as any other law that we pass.
If I can speak to that briefly. So California has a mini FTC Act. The big FTC Act in Washington does not have private rights of action. The California mini FTC Act does allow it. I can say, based on my research, there has not been a flood of litigation under the existing statute. I found one case in Adobe Systems from 2014, Judge Lucy Coe, Northern District of California, who found on the facts alleged that there was an injury in fact that was alleged under that statute. That's the only law that I found. Actually, once they started doing discovery, they found that the data had not been encrypted, had actually not been lost to the extent that they thought, and there was a settlement. So no signs of a great amount of litigation, but the notion is, also if I can say, that the law sets up two steps: first name and last name, and then other. I
think my question's been answered.
Okay, I'm sorry.
Professor, didn't mean to interrupt. Assemblyman, how does your bill differ from AB 964, which is also on our agenda today?
Forgive my ignorance, but I don't have them all memorized. My colleagues tend to introduce a lot of laws.
Chow's bill? Don't know it? Okay. All right, thank you. Do you have any closing remarks?
Yeah, so we have indeed, as the witnesses who expressed our opposed indicated, we have indeed had a very productive year working with them in terms of finding just the right definition. It is worth underscoring 3 points. The first one is this law gives tremendous flexibility for business in terms of what is appropriate. Obviously a signature would require far less security measures than, say, someone's fingerprint coupled with their geolocation information. So again, the flexibility of the reasonably prudent actor standard does give a lot of flexibility in terms of the different things that we include in it. Secondly, we want to be clear. I'm more than happy to take an amendment if needed to clarify that geolocation data, which we view as the aggregate of someone's, say, their Uber or Lyft ride-sharing pattern, by which you could easily stalk somebody. We're willing to clarify, of course, that that is not just simple as a residence address. I mean, that's something that we do not intend to include in the bill. And third, I want to stress that we are mindful of the pending fights that many of the witnesses referenced, that there will be perhaps things that they're seeing in their crystal ball having to do with the California notification statute, but it's worth underscoring that this bill does not do anything on the notification statute. It just has to do with establishing reasonably prudent standards for certain classes of data breaches. And with that, I respectfully ask for your vote.
Thank you. Do I have a motion?